I dedicate this video to John Marazan. He was my friend and a police officer who dedicated his life to protecting people, and he helped to create this channel, the Police Roll Call channel. This Police Roll Call. I am Stanley Cohen. I'm an attorney at law and a former City of Cincinnati, Ohio police officer. The goal of this channel is to explain appellate court decisions to assist police officers in enforcing the law on the street and to enable police officers to defeat defense attorney motions to suppress evidence and to defeat defense attorney motions to dismiss charges, and to assist citizens in general to understand their rights under the Constitution. The decision I'm going to discuss today is Commonwealth versus Cunningham. It was decided by the Superior Court of Pennsylvania in 2022. Police officers in the United States are entitled to cite this opinion in any court of law if the facts in the officer's case are sufficiently similar to the facts in the court opinion, and if the court's opinion is sound and reasonable, which I believe it is. The facts of this case are as follows. In Cunningham, two police officers were on patrol. They smelled the odor of burning marijuana, and they understood that under the Medical Marijuana Act, the smoking of marijuana in public is a crime. And at the time, they saw several persons standing on a nearby corner, so they decided to go over and check these persons out. They went up to them, and they explained that they smelled burning marijuana, and they asked the individuals for their names and identification. These persons became angry and aggressive, and they started to encircle the officers. The officers felt threatened at this time for their safety. Now I'm going to pause at this time and ask a roll call question, and here it is. What action would the law authorize the officers to take on these persons? By the time I finish the opinion explaining this case, you will know the answer. The officers patted down the defendant, one of the persons in the group, and he found a gun on his person. The person admitted that he did not have a license to carry the weapon, and so the officer arrested him for that crime. In court, the defense attorney made a motion to suppress the gun because the search was illegal under the Fourth Amendment. The court granted the motion and suppressed the gun. And they did it on this reasoning. The officers had firearms on their person, and they could have protected themselves by using their own firearms, and it was unnecessary to pat these persons down, and thus the Fourth Amendment was violated. The Commonwealth appealed the case, and in the appeal court, it was ruled that the trial court made an error and that the trial court's opinion should be reversed. The appeal court reasoned this way. The Fourth Amendment states as follows: the right of the people to be secure in their persons, houses, papers, and personal effects shall not be violated. They have a right to be protected against unreasonable searches and seizures. And so the court applied this amendment in this way. When these individuals started to encircle the officers and the officers felt threatened for their safety, they had a right to pat the individuals down, to feel for weapons, to protect themselves. They weren't required to stand by and rely upon their firearms to protect them. So the court, on this reasoning, ruled that the Fourth Amendment was not violated. There was no unreasonable search and seizure by these officers. And this is the opinion. And if you would like to watch future court decisions like this one, please subscribe below.